Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath of affirmation, announcements by the President, bills brought from the House of Representatives, petitions, papers.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Health. The ministerial response of the Ministry of Health to the 20th report of the Public Accounts Committee, 3rd session 2017-2018, 11th Parliament, on the examination of the report of the Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2017. Madam President, I seek your indulgence to stand down for a while. Question number 2 for the Minister of National Security. He should be here within the hour.
Senator Mark.
Thank you. To the Minister of Health, in light of reports of a tuberculosis outbreak at 2 TNTech offices, can the Minister indicate what is being done to avoid the spread of this disease?
Minister of Health.
Thank you very much, Madam President. Madam President, may I put the following facts on the table? Fact number 1. There is no outbreak of tuberculosis at 2 TNTech offices. That's an important fact. There is no tuberculosis outbreak at 2 TNTech offices. You have one person, a TNTech employee, who contracted TB, who worked at 2 separate TNTech offices. Those are the facts. The pillars in treating with any person who has tuberculosis are as follows. Any case of suspected TB is reported to the thoracic unit at Cora, which was done. Simultaneously, case treatment is started according to WHO guidelines. That was done. Simultaneously, public health measures via the thoracic unit and the county medical officer of health, for Caroni in this case, was done at both sites, both TNTech sites. Also, public education and sensitization was done with the thoracic unit at Kings Village on the 21st of March 2019, and on Thursday, 11th April, at TNTech Central Stores, the 2 sites where this one person worked. More lectures and advice and public education are carded for today. May I also put on the record the 4 latent cases which were traced. People with latent TB are not infectious. They are not infectious. They cannot transmit the disease unless something else happens. That is they are either immunocompromised, and they will be treated according to WHO protocols. Thank you very much, Madam President.
Senator Mark.
Madam President, through you, can the Minister indicate, apart from education lectures, can you advise what specific measures are being employed to allay the fear growing among the workers at those two sites identified?
Madam President, I think I just answered that. You allay fears by public education, and we held those consultations with the employees. And I also indicated in my substantive answer that the 4 cases of latent TB, and let me just put on the record, WHO estimates that 1/4 of the global population has latent TB. 25% of the globe, of 6 billion people, have latent TB. Let me put that on the record. So all of us in this room could have latent TB. So what you do to allay the fears, and these fears are rational on behalf of the TNTech workers, we are going to start treatment on those 4 persons who have been confirmed to have latent TB. Thank you very much, Madam President.
Chair. Madam
Senator
President.
Dylan Remy.
Yes. To the Minister of Health. Sorry. To the Minister of Health. Could you indicate whether in Trinidad and Tobago currently we have any issues with drug resistance and in treatment of TB?
Thank you. Thank you very much, Senator. That's a very good question to ask. Madam President, the incidence of drug-resistant TB is a global issue that has visited the world over the past few years due to the overprescribing and easy access of antibiotics globally, and also the overuse of antibiotics in animal husbandry. This has given rise globally to the problem of antibiotic resistance. And it is a particular concern for TB patients because the drug therapy for TB patients is that you're on a cocktail of drugs, 3 to 5 drugs, which you must take multiple times per year for 6 to 12 months. That's a very onerous drug regimen. And what happens is that people start the drug regimen, as you might know, doctor, start to feel good, and then stop it. When you do that, the bacteria in your system, and you start back drug therapy, those bugs, those TB bugs become resistant to the antibiotics that you are going to start back. So we always have to caution people, beg, cajole, whatever, that you need to stick to your drug regimen, whether it's 6 months or a year, otherwise you will develop antibiotic resistance. That is a very serious global issue due to the overuse and ease of accessibility of the general population to antibiotics and its misuse and overuse in animal husbandry. Thank you very much, Madam President.
Senators, may I just remind members that we will revert to this item when the Minister of National Security comes to the chamber.
Questions on notice, questions for oral answer.
Thank you very much, Madam President. Madam President, the government will be answering today questions number 103. We ask for deferral of questions 110, 111, 204, and 205 for two weeks.
Questions 110, 111, 204, and 205 are deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 103 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, the Ryder Scott 2017 reserves audit commenced in March 2018 and was completed in August 2018. The proven reserves increased from 9.92 TCF, trillion cubic feet, in 2016 to 10.52 TCF in 2017, an increase of 0.6 TCF, or 6%. Probable reserves on risk increased from 5.38 TCF in 2016 to 6.13 TCF in 2017, an increase of 0.75 TCF, or 13.9%. There was also an increase in possible reserves on risk from 4.72 TCF in 2016 to 5.39 TCF in 2017, an increase of 0.67 TCF or 12.5%. The reserves to production ratio based on 2P, which is the sum of the proven reserves and probable reserves, using a production rate of 1.14 TCF for 2017, is 14.6 years, which is a 16.6% increase from 2016 reserve to production ratio of 12.6 years. Madam President, please note that the year 2017 is the first year to reflect a year-on-year increase in reserves since 2004. Let me repeat that. 2017 is the first year to reflect a year-on-year increase in reserves since 2004. And I'm also pleased to announce that the production has also been increasing tremendously in 2019. Madam President, the Ryder Scott Reserves Report contains sensitive information on the reserves of upstream companies, which for commercial reasons cannot be disclosed. In this circumstance, the government is prepared to make available an abridged version of the report, which provides an overview of the country's reserve position and still maintaining the confidentiality of the natural gas reserves of the individual upstream companies.
Madam President, can the Minister indicate whether this particular report in the past was tabled in the Parliament?
Minister.
I'm not sure, but if it was tabled at all, it must have been an abridged version, because we cannot disclose to the public the individual reserves of the individual operators.
Senator Mark.
President, can the Minister indicate when this abridged version of the report will be tabled and circulated?
Minister.
Well, it is almost completed by the Ministry of Energy, and then it has to be approved by the Cabinet prior to, like everything else, it must be approved by Cabinet before anything can be laid in the Parliament.
Senator Mark.
Can the Minister indicate when this report will be approved by the Cabinet for circulation and tabling in this Honourable House?
Minister.
As soon as it is approved, but we're trying to make that happen as soon as possible.
Senator Mark.
Madam President, can the Minister indicate what were the factors responsible for the increase in the production reserve of natural gas?
That question doesn't arise,
Yeah,
Senator
you
Mark.
did indicate something.
Yes, but the question doesn't arise. Any more questions?
Public business, government business, bills, second reading.
President, may I ask, all the questions have been reserved except the one that I have asked? Or just only my questions that have been reserved?
I had indicated already that questions 110, 111, 204, and 205 were deferred for 2 weeks. You will notice on the order paper the procedure for question 132. There was a procedure invoked in respect of question 132.
President, may I ask of you, in the appendix, question 194, written response?
Question 194 isn't due as yet, Senator Mark. I believe it was deferred for 2 weeks. It was deferred for 2 weeks on the 11th of April.
Oh, it was deferred for 2 weeks. Okay, thank you.
Business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that an act to provide for the establishment of the Civil Asset Recovery and Management Agency for the recovery of criminal property through the use of the remedies of restriction in dealing with civil assets, restriction and forfeiture in criminal property, and the management of criminal property and unexplained wealth orders and matters incidental thereto be now read a second time. Madam President, 45 minutes will simply be a difficult time frame to discuss the merits, proportionality, and ramifications of a bill as significant as this. I dare say that in the time that I have spent in the short number of years in this Parliament for the last 8, nearly 9 years, I consider that this particular bill is perhaps the most important bill that I have seen come across the desk of the Parliament. And I say so because the legitimate aim of this particular bill is squarely directed towards ensuring that the battle against criminality, which we all support, is taken squarely to where it is perhaps most effective, and that is in taking the wealth or profit out of crime. For far too long as a country, we have invested ourselves in the reforming of laws. Bit by bit, we raise jail terms, we raise offenses, we tweak those laws year after year. And this government decided that it would focus upon, instead of that formula which has not brought benefit, we decided that we would focus upon two particular aspects of improving the criminal environment and the attack on it by the state. We said that we would do two things. One, we would focus squarely on the rapidity of improvements in the criminal justice system. And secondly, that we would focus in laser-sharp direction upon taking the proceeds out of crime. Those are the two things. We spent a considerable amount of time working on the opening of new courts, rules, removal of backlog systems. We brought to the Parliament and to the country data never revealed before. Now to a point where it is accepted in our Parliament, we know the number of preliminary inquiries in arrears, we know the numbers in the magistrates' court, we understand what judicial capacity looks like. And in summary, we came to the criminal justice system, we introduced the criminal proceedings rules. Secondly, we introduced the merger of jurisdictions in the family and children division and in the criminal division itself. We moved legislatively the indicator of the number of judges to sit in matters by 77%. We added in a methodology to treat with children in the children's court. We added in the removal of hundreds of thousands of matters that were clogging the system in the motor vehicle and road traffic arena. We saw the opening of new environmentally creative sections of the criminal justice system. In particular, I refer to the children's court. We added in the layers of the operations in the Director of Public Prosecutions, in the Trinidad and Tobago Police Service. And this Friday, the Commissioner of Police, people may not have noticed, but I did, launched the revelation of a specialist financial investigation division right here in Trinidad and Tobago in a fashion that has never been seen before. And I'm sure there'll be more to say about that. Coming out of the criminal justice system, our focus on white-collar crime, including blue-collar and black-collar crime, was to be found in the anti-gang legislation, was to be found in the improvements to the Proceeds of Crime Act, customs legislation, financial obligations legislation, FIU legislation, in getting money laundering as a triable either way, in getting maximum sentence indication, plea bargaining. All of these arrangements take us to this bill now. So what does this bill do? This bill effectively has four purposes. Number one, it creates an agency. Number two, it says that the remedies to be used in the operation of this law are of effectively two kinds: restriction orders and forfeiture orders, which come on the back of a civil asset route of forfeiture or an unexplained order route of forfeiture. We then deal with the management of that which is forfeited or seized. And lastly, we have an entire section on unexplained wealth orders. This law, Madam President, was very carefully drafted, and it came about as a result of two factors. One, the local context, which I've already described, this government's agenda to follow the money that comes out of the proceeds of crime. And secondly, to meet our international obligations. Now, we do know that since October of last year, I've been reminding this Honourable Senate that we will be coming specifically to treat with a suite of legislation. We dealt with the Companies Amendment legislation. We have dealt with the non-profit organizations legislation. And we have now brought to the table this particular law, the civil asset forfeiture, being the last three out of the pack that we brought forward. And we indicated that we have a face-to-face review with the Financial Action Task Force in the week beginning the 21st of April, which is this month. At that review, we're required to demonstrate that Trinidad and Tobago has prospered in its own agenda, because we set the agenda and putting the follow the money obligations, including this, marry in with the FATF and the CFATF obligations. Now, they're squarely rooted in recommendations 4 and 38 of the FATF recommendations, immediate outcomes 2 and 9 specifically. And, Madam President, I want to say that they are also grounded in a significant part of the United Nations laws, treaties, which we as a country have adopted for our own benefit. And there's, in fact, a very useful case, the case of Gogitise and others versus Georgia. It is coming out of the Strasbourg jurisdiction. It's dated the 12th of May, 2015. It's application number 3686205. And I recommend this particular case to all those who may be interested, because coming out of its analysis, there was a reminder in the European Court of Human Rights setting, which has considerations of constitutionality exactly the same way we do from the European Court of Human Rights perspective and the Council of Europe and their written aspects, which look at entrenched rights the same way we do. There was a whole recitation which I thought was very useful. In this particular case, this case concerned public servants in Georgia, that is in Europe. And in that, they were looking at the fact that there were several notes that public servants in that jurisdiction owned a considerable amount of property and that their asset base could not simply have afforded that. And in that, they looked at the provisions, the constitutionality in particular. They focused upon that which is the allegation of discrimination. They looked at the protection of property rights. They looked at the principle that there ought to be no criminal punishment without law and prohibition of retroactive application of criminal law. And they looked at innocence until proven guilty and the burden of proof. Similar issues to that which we look at. And in short, in looking at what we call the in rem proceedings, they recognized that there was a square proportionality and legitimacy, that there was no breach of constitutional provisions in the European context, which is very similar to our own enshrined rights context. But what I found very useful is the number of conventions that they looked at, being the United Nations Convention Against Corruption, the Council of Europe conventions, the Financial Action Task Force methodology, the Council of Europe Committee of Experts on Evaluation of Anti-Money Laundering, called MONIVAL, and the Council of Europe Group of States Against Corruption, called GRECO, and the OECD anti-corruption measures. Now, I've put that onto the record because the similarity of jurisdictions to ours is quite stark. And in summary, this European court upheld the constitutionality of laws in Georgia, which very much resemble the laws which we're treating with right now. And for the record, Madam President, let me just add on to that which I've said, that we did look at a number of jurisdictions in crafting this law. The United Kingdom, the Criminal Finances Act, Unexplained Wealth Proceeds of Crime Act, Civil Asset Forfeiture. In Australia, we looked at several of their federal states. We looked at the Australian Commonwealth Proceeds of Crime Act 2002, Western Australia Criminal Property Confiscation Act 2000, Northern Territory Criminal Property Forfeiture Act 2002, New South Wales Criminal Asset Recovery Act 1990, South Australia Serious and Organized Crime Unexplained Wealth Act 2009. We looked also at Canada. We looked at a number of provinces there. We looked at Ontario, Civil Remedies Act 2001, British Columbia, Civil Forfeiture Act 2005, Alberta, Victims Restitution and Compensation Payments Act 2001, Saskatchewan, Seizure of Criminal Property Act 2009, Manitoba, Criminal Property Forfeiture Act 2004, Quebec, in their Forfeiture Administration and Appropriation of Proceeds and Instruments of Unlawful Activity 2007, New Brunswick, Civil Forfeiture Act 2010, Management of Seized Forfeiture Act 2012, Nova Scotia, Civil Forfeiture Act 2007. We also looked at Jamaica, Proceeds of Crime Act 2007 as amended, St. Vincent and the Grenadines, Proceeds of Crime Act 2013 as amended, Antigua and Barbuda, Proceeds of Crime Act Amendment Act 1993 as amended in 2014. Guyana, State Assets Recovery Act 2017. Cayman Islands, Proceeds of Crime Act 2016. And Dominica, Proceeds of Crime Act 1993. And the Commonwealth Law Model, which is modeled after the publication on the UNODC, the Commonwealth, and the IMF. Now, I've put all of this onto the record, knowing that the courts are there to interpret law, so that I can anchor to the point that all of these jurisdictions and the case law coming from these jurisdictions have informed us in the creation of this legislation, and in particular, the proportionality, the legitimate aim, and what constitutional prescriptions, if any, we ought to consider. So let's stick a pin for a moment and treat with the issue of constitutionality. And let us say that we did look very carefully at issues of constitutionality. We are of the solid view that this particular legislation does not require any 3/5 majority support. And we say that because we anchor ourselves in the traditional arguments to be found in Francis, in Maraj, in Surat, in De Freitas, in any one of the leading cases that treat with proportionality. We have covered the three aims of proportionality. Quite simply put, it is not every 3/5 right that is touched by a piece of law that requires 3/5 treatment, provided that there's a legitimate aim, the measures are rationally connected to that aim, and you go no further than you need to in treating with the law. There's a further qualification in the round of proportionality, which says if your law is effectively encompassing law which is known to you, then you are in safe ground. And I point immediately for the lawyers in the listening public and here to the fact that we have civil remedies right now in the form of ant and pillar orders, in the form of Mareva injunctions, and in the fact that there is civil authority enforcement to criminal proceedings conducted by the state by the Attorney General pursuant to Section 76(2) of the Constitution. So this is known to the type of law in Trinidad and Tobago. We adopt and implement the due process considerations very carefully, and needless to say, the major subset of due process is national security and the balance of rights for citizens, the protection of law that ought to be offered, and therefore, in short form, I say this law is entirely constitutional, and that we ought to confine ourselves now to how this law will operate. The bill itself has 76 clauses, 3 schedules, and it is anchored in the parts that I've mentioned previously. So let's jump directly to this bill. The first 2 clauses are traditional. The short title, Act shall come into force by proclamation, Clause 2, but Clause 3, which treats with the definitions clause, is very interesting. I want to point out the fact that associated property is defined, because that is property which you can treat with in a different way from actual criminal property. Cash is defined. Civil asset recovery is defined as the 3 things: restriction or forfeiture of criminal property or the use of unexplained wealth order. And then we go into what criminal conduct is, what this law treats with. Criminal conduct becomes relevant because when we look to what civil asset forfeiture involves or what unexplained wealth orders involves, they are rooted in the concept of criminal conduct. Criminal conduct means conduct which constitutes a specified offense, or if it occurs in a country outside, would constitute an offense in that country, and if committed, would be a specified offense. What is a specified offense? It is defined at Section 2 of the Proceeds of Crime Act, and it is done by way of reference to the second schedule of the Proceeds of Crime Act, where we list out specifically those things which are the launching pad for this law. And permit me to put it onto the record, Madam President, that we are looking squarely participation in organized criminal group racketeering, terrorism, trafficking in human beings' body parts, sexual exploitation, illicit trafficking in narcotics, illicit arms trafficking, illicit trafficking in stolen other goods, corruption and bribery, fraud, counterfeiting currency, IP offenses, environmental crimes, murder, grievous bodily injury, kidnapping, robbery, theft, smuggling, tax crimes, extortion, forgery, piracy, insider trading, money laundering, offenses against gaming legislation. Those offenses are the springboard for the operation of this law. You must be being investigated by the law enforcement authorities, who are the Commissioner of Police, the Board of Inland Revenue, or Customs Division. They must be investigating you for a specified offense as defined. And in the course of that investigation, there are two routes to run. On the first hand, you can run the civil asset forfeiture route via a trustee. The investigating officers approach the Director of Public Prosecutions. The Director of Public Prosecutions considers their suspicion. He must indicate that there is no sufficiency to go for a criminal prosecution as yet, but that there is sufficient evidence to launch a civil asset consideration. The Director of Public Prosecutions takes suspicion to sufficient evidence. After sufficient evidence, he refers the matter in writing to the civil asset trustees. The civil asset trustees then approach the court, and then the court considers if there are reasonable grounds. So I want to caution, there is not a launching pad on the basis of mere suspicion. There's a graduation. All investigating people start with suspicion, but when you get to the court, you're looking at anchored grounds. So it isn't anything other than by way of that process for the civil asset route, and then under the unexplained wealth order, you approach the court again to move from suspicion to reasonable grounds and sufficiency of evidence. It's very important to note that criminal property is defined, but that not all criminal property is what we call recoverable. The civil asset forfeiture regime, the unexplained wealth regime, only relates to what we consider recoverable property. And recoverable property is specifically defined in the context of two important clauses. Clause 7, which says that recoverable property is not that which is, importantly, on a balance of probabilities, property obtained in good faith for value. In other words, then, you can find yourself looking at property which is not recoverable property if there's a bona fide third-party interest. That is further amplified by other sections in the bill, Clause 34, Clause 35, Clause 38, Clause 50. And in there, we recognize third-party rights and interests. And very importantly, if you look to the provisions of Clause 50, that is an exceptionally important provision. Clause 50 treats with legitimate owner. And a legitimate owner takes property out of the realm of being recoverable property. Now, Clause 4 of the bill deals with the applicability of this law. I'm sorry, I've got very short time. Forgive me, I got 10 minutes left. So, in the Clause 4 of the bill, we're looking at the applicability of this law. And we say it applies to things which existed prior, but very importantly, insofar as the second schedule of POCA includes tax matters, we accept out the operation of this law from a taxation purpose. We say that it only relates to tax issues 6 years backwards from commencement. Why? Because the Income Tax Act, the other laws that treat with taxation, put a positive obligation on people to hold records for 6 years only. And therefore, it would be insane to ask the population to resurrect paperwork which they have thrown away in effectively resurrecting the dead. So it is a proportionate issue to limit taxation issues. Part 2 treats with the civil asset trustee. And in those clauses 8 onward, just let me quite simply say, if ever we wanted a model of how to appoint an entity right, it is this law. We say that the civil asset trustee is to be appointed in very secure, insulated circumstances. Number one, as to the 3 trustees, 2 of them by the Judicial and Legal Services Commission, the second one by way of agreement between the Leader of the Opposition and the Prime Minister, and if they can't agree, by the President acting in the President's sole discretion. We then also make sure that we say that their terms and conditions cannot be derogated to their disadvantage. We anchor them to the SRC within the provisions of the Constitution, Section 141. We then provide for their conflict provisions in the management of their functions. We provide for powers. We provide for functionality. We also provide in this section for the issuance of a property manager. And the property manager is effectively that version of creature equivalent to a receiver by way of a court order. And we make sure that the property manager is appointed only by the purview of the President acting in sole discretion. So there's a complete insulation away from the executive members. Whilst I'm on the executive insulation, let me point this out. Right now, the Attorney General, who in our Constitution is a political appointee, can be called upon by the criminal arm of the state, those with vested responsibility, the office of the DPP, to actually go to court and freeze property. And what we have done by this legislation is to say, we are going to remove the Attorney General from that rule. And we're going to vest that role solely in the civil asset trustee or in the court. And therefore, we provide a huge change to the way that we do business in our constitutional structures by removing an Attorney General's participation from this type of law. Let me turn, Madam President, to Part 4 of the bill. Let me say that, suffice it to say, in Part 3, we jump through financial provisions. We anchor where the money for the trustees to come from, the order of prioritization from clauses 20 go forward, how that money is to be applied, how it is to be accounted for. We make it subjected to the provisions of the Auditor General pursuant to Section 116 of the Constitution. We apply IFRS standards. We take the audit, we lay the audits, we lay the provisions in the Parliament in the regular cycles. We set the financial year end. When we get to Part 4, we're dealing with civil asset recovery. Madam President, may I ask the precise time that I must end in full time?
You finish at 1 minute to 11.
Much obliged. When we get to Part 4, which is the civil asset recovery, here, Clause 31, anchor point number 1, where during the course of a criminal investigation for a specified offense, Commissioner of Police or person delegated by him not below the rank of Superintendent, Controller of Customs and Excise, Chairman of Board of Inland Revenue, has reasonable grounds to suspect that the offense involves recoverable property, he may forward a report to the DPP. The DPP then, under subclause 2, must determine that there is insufficient evidence to pursue criminal charges, but that there is sufficient evidence that the property is recoverable, and we then allow for the fact that a defendant may be treated with if the defendant has absconded, is outside of Trinidad and Tobago, is too ill to face trial, or has died. And specifically, we then go into the parameters of making sure the trustee does an equity valuation for the thing which is to be treated. We then show how the property restriction orders are to be applied for. Under Clause 33, we say you must go to court, you must file your evidence, you must approach the court for consideration, you must set out your grounds, you must identify why you are saying this person ought to be treated this way. You then provide for the prescriptive remedies, when you are to serve, who you are to serve, how you are to publish. You ensure that the methodology to obtain a forfeiture order, which is the next step, only happens if it is inter partes, meaning between the parties. All parties are provided with the rights of attendance. All third-party interests are to be heard. Anybody can approach the court, ask the court for a variation of the order, ask the court to treat with that which is the subject matter in different ways. For instance, we have categorized if it is mixed property, if it is joint ownership, if they are company shares, if it is vessels, if it is real property. We have treated with all of the typologies and species of property, and we make sure at all points in time that there is an ability to approach the court. Very importantly, there's a clause in here that says, whilst the state has seized your property, under this interim position, the state can't use your property. And that is a very important provision because the state in past incarnations, in fact, went on to use people's property in ways that they couldn't explain. And we are putting these assets under the strict management of the civil asset trustee, and the civil asset trustee has full accountability to a court of law, subjected also in the event that they have not acted in good faith to criminal and civil prosecution. We do provide for a very robust mechanism to allow for the insulation of the civil asset trustee and property managers. As it relates to the trustees, we borrow from the elements of Section 55 of the Constitution, which provides criminal and civil immunity, provided it is in good faith, and for the trustee, for civil immunity, so that people are ensuring their functionality. This is no different, for instance, from Section 44D of the Central Bank Act, where similar types of immunity are granted to persons acting in those circumstances. We then go on, Madam President, Clause 35, you'll see the further orders. Clause 38, again, further orders. We then go on to the process by which the court makes the orders in the next stage, the civil asset forfeiture order. That begins at Clause 44 of the bill. When we get to Clause 44, importantly, we say that the civil asset forfeiture order is to be something considered in rem. What does that mean? Against the thing. It is not in personam, which is against the person. This is a critical underpinning of the constitutionality of this law. This law allows for forfeiture against a thing without a determination of guilt against the person. If we were to be affecting the person, the innocence presumption until you are found guilty would imply that you are treated with here in a different way. Also, too, the rights against self-incrimination, etc., would require a different form of treatment. This in rem philosophy has been upheld in a number of jurisdictions, in particular the Eastern Caribbean Supreme Court in the Court of Appeal, Antigua and Barbuda, in ANUHCVAP 2015, case number 0035, the case of Ahmed Williams and the Supervisory Authority, judgment of February 28th, 2017, in the United Kingdom, in the case of the National Crime Agency versus Mrs. A. It is the High Court of Justice, Queen's Bench Division, case number CO754 of 2018, and that judgment of Mr. Justice Supperstone, and then also in the European Court, Strasbourg Court, in the case that I have referred to already. All of these treat with the difference between in rem and in personam, and that the in rem route, which is an administrative procedural route, does not treat with the person. Now, is that any different from Trinidad and Tobago? No, and let me explain it this way in a very simple way. Right now, somebody may make an allegation of fraud. They say, look, somebody has a false deed, they forged my deed, they sold my property to somebody, I never sold it. They make a report to the fraud squad. The fraud squad has its investigation ongoing. They then go to a civil court and they ask in the civil court for that property to be injuncted, frozen, and for the registrar general to rectify the register so the property is returned to that person. So there are already examples of civil and criminal at work, and there is nothing to stop a civil court of saying to the registrar general, change the title, because we made a determination on a balance of probabilities in the civil arena. Second point, under the Proceeds of Crime Act, in Section 32 in particular, and then Section 39, where we deal with cash forfeiture, etc., the standard for treating with giving the investigative authorities power to enter, to seize, to make you disclose your assets, to comply with anything is to be found in Section 32. In particular, subsection 6, where you have reasonable suspicion to a police officer and a court says, go and get the property, bring it in, make the person give you all evidence, etc., all done on a civil standard. So our Proceeds of Crime Act, our civil law, our enforcement by the civil authority, the Attorney General, as an aid to criminal investigation and criminal process, all tell us that our existing law has this. What our existing law does not have is a codified, insulated structure which is why we have brought this legislation to improve Trinidad and Tobago's weaponry against criminality. So, Clause 44 treats with the civil asset forfeiture route, in particular how the application is to be made, who is to make the application, the grant of the asset forfeiture order in Clause 5, that the court may actually enter into forfeiture, etc. And very importantly, if you look at Clause 45.3, you see that there are strong similarities to the Mariva process, for example. By Mariva, I'm referring to the fact that there's well-known common law anchored in the case of Mariva. It's now trite law that you can actually go and freeze property, bring it in, and in fact, you can freeze it on a worldwide basis, as they have applications called worldwide Mariva injunctions. We then allow for the manner in which the accused is to be treated. If your property is frozen, where are you getting money from to pay your legal expenses, your mortgages, your management, your health, your obligations? All of these are specified in the law in prescriptive form to allow for a balance and proportionality in the manner in which you seize and in the manner in which you manage. The court then allows for a notice to the public. It allows for that to be published so that all people that have an interest in the property are managed. They allow for the right for audience and hearing by third parties and persons who have interest in the property. That's where we're running up to in Clause 50, which I mentioned a little while earlier, where you have the legitimate owner having the power to ask for it to be set aside. So if in the course of hearing an application for civil asset forfeiture order, the High Court is satisfied on a balance of probabilities that the property that is the subject of the application is recoverable property, but that a person is a legitimate owner, the High Court shall make such order as it considers in the interest of justice. And then we say what criminal property is, what a legitimate owner is, rightful owner before the property was acquired in circumstances that don't involve the criminality. It was acquired in good faith and for fair value after the criminal conduct, and the person could not and did not have reasonable cause to know that the property was criminal property, etc. So we have very specific points. Then we go to specific requirements for certain types of property from clauses 52 onward, where we treat with the different species, land, vessels, motor vehicles, how the registries are to be treated with. We marry up the civil law restrictions for lispendants, which is notice to the world that they're pending proceedings. We allow for restrictions in the same way that they happen. And we marry again the civil aspect of judgments. Judgments are in existence every 3 years. You must re-register. They last a matter of course for only 12 years, after which they efflux. So we've brought all of these civil laws. We've codified the laws in a very sensible and reasonable way. We treat with listed assets and how they are to be managed. Listed assets are defined in the legislation. They include chattels which are of great value, paintings, gold, watches, postal stamps, etc. I can tell you, quite interestingly, as Attorney General, in the Office of the Attorney General, there's a painting which I came across. My permanent secretary said to me at one point we needed to insure this painting, and I asked why. Because it was over $1 million of worth. I said, well, what are we doing with $1 million painting? Only to realize that it was proceeds of crime given back to Trinidad and Tobago by the US government in the Piarco Airport inquiry, received by Anand Ramlogan, hanging in that office in silence without measure. That kind of asset will not be hanging on my wall as the occupier of that office for the time being. It will be put with the civil asset trustee, where it should properly be in terms of the repatriation of criminal proceeds to Trinidad and Tobago. Unexplained wealth orders are dealt with in Part 5. Now, this is a particularly interesting and dynamic aspect. This unexplained wealth order is not unusual in the context of the Proceeds of Crime Act, Section 32 in particular. When you look to the conditionalities in subsection 6 of the Proceeds of Crime Act, you can be called upon to explain your wealth. Senator Vieira would know part of the remedies in the Companies Act, Section 245, under oppression remedies from 242, allow you to ask somebody to come to court and file a declaration deposing to your assets, etc. So we have these iterations of the law in numerous places, and what we're doing is we're codifying it as we produce this legislation. Again, unexplained wealth orders can only be offered by the court if the police are in the course of a criminal investigation. And importantly, stick a pin, we're saying that there must be a threshold. And here you'll notice at clause 58, we've prescribed $500,000 threshold. I want to draw an immediate caveat. The second schedule of the Proceeds of Crime Act does not right now have gang activity as an offense. We could not amend the Proceeds of Crime Act, second schedule in this law. We will be amending the Proceeds of Crime Act to introduce gang activity and gang-related offenses into the schedule. And we will be adjusting this threshold as it relates to gang activity to a much lower threshold, because we are absolutely intent on taking, via due process, the fighting chance against long gold chains, cars that are worth significant value, against people who are generally seemingly unemployed and who have unexplained wealth. And in our country, where we can be celebrating a song called the Zessa and glorifying a Zessa man with a Glock and a Beretta and enticing young people to join gang activity because of the bling, we intend to take the bling away via the court considering if you can explain your wealth. So message to all Zessas in this country: keep your receipts, show where you got it from your employment, put your trail of evidence together, or make sure that you are not on that block demonstrating unlawful gains, because a court of law will be asked to look at you very carefully. We then go to make sure that the declarations are prescribed. We deal with offenses for false declarations, etc., the grant of the preliminary orders, and then we allow for the variations. And what happens is, if you cannot explain your legitimate wealth, remember, it's only in relation to recoverable property. Not all property is recoverable. Your grandmother may have given you something that may be explainable. It does not flow from the offense which you're being investigated. Some third party might have it. All of that can be explained in a court of law. We make sure that there is a specified, measured approach to explaining yourself. We don't ask people to panic. We ask people to just be prepared. Those of us who are persons subjected to the integrity and public life provisions, we have been disciplined to file our returns every single year. I believe I may have been doing it for approximately 13 to 15 years. I can't remember the exact time, but I can tell you that it has been very painstaking in your obligation to explain yourself. I then ask, Madam President, that we look to the property outside of Trinidad and Tobago in Part 6. We allow effectively for an anchoring of mutual assistance and cooperation, not too dissimilar from the Mutual Assistance in Criminal Matters Act, which treats with extradition and law enforcement and reciprocity. We allow for the operationality of treaties or agreements between jurisdictions. We allow for the enforcement of orders. We allow for the enforcement of assistance in foreign jurisdictions, where we can knock on the door of a foreign jurisdiction and say, listen, we are investigating a matter in Trinidad and Tobago. We believe that there may be unexplained wealth in your jurisdiction. Can you, through your due process routes, assist us with the explanation of wealth? And that is a very important feature of this legislation. Part 7 treats with asset management from clauses 71 go forward, the duties of the property manager, how it is to be reported, the realization of forfeited assets. And then Part 8 treats with the miscellaneous provisions, the confidentiality, the strict confidentiality, the offense for breach of confidentiality, and the promulgation of regulations for the manner in which we treat with it. The schedules, Schedule 1 deals with the oath, Schedule 2 deals with the form, Schedule 3 deals with the consequential amendments. 5 minutes, much obliged. So, this law is comprehensive. This law has been through significant stakeholder consultation. This law is law which thinks outside of the box. This law has very careful safeguards. This law ensures, in particular as it relates to taxation issues, taxation is something that should be separated out. That 6-year chain is the only aspect which needed to be balanced inside of this. There are some amendments that we need to treat with. For instance, we need to tidy up in some of the clauses that we've referred instead only to police officers. Really, it should be the 3 categories of people. And there's one clause, in fact, that we need to remove entirely, a subclause. Inadvertently, we had maintained in the draft of the bill the fact that the civil asset trustee can knock on the door of any statutory authority and obtain information without regard to secrecy provisions. That would infringe the privacy right. That has to come out. So that was a slip in terms of one of the original drafts. We'll be proposing some amendments in that context. I just say to all listening, this law ties in with a whole lot more. It ties in with the beneficial ownership companies. It ties in with the merger of the proceeds of crime, the treatment of crimes either way. It ties in with the serious investigative work that we've been doing against gangs. We have a commissioner of police who is tracking gang activity and intelligence agencies that are doing it. And right now, whilst gang members are being investigated, this forms a nuclear device in that battle, because we can start to approach their property in due process whilst the gang activities are being measured. This provides an opportunity to tie into another piece of law which is on the table of the House of Representatives, and I want to flag that now. I want to mark the spot today. We have laid in the House of Representatives the bill to treat with registration of deeds, how you treat with trusts, how you treat with the abuse of equity where you do not complete your registration requirements. And Madam President, what I can say as the first occupant of the Office of the Attorney General from a corporate commercial background, not an administrative lawyer, which is where most of our attorneys general have come from. Because administrative law is, and I mean no disrespect, it's fairly cookie cutting. Breach of natural right, failure to promote, constitutionality, that's fair cookie cutting law in some senses because the law applies over and over in each instance in the same way. Where you really get to the heart of this is when you tie in FATCA, foreign accounts, Global Forum, foreign accounts, beneficial ownership, manner in which you treat with property, the due process requirement for inspection and revelation. All of these give us a fighting chance, particularly when the Commissioner of Police of this country is somebody who is able to say, the buck stops with me. And where a Commissioner of Police is able to say, a financial investigation division will be created, insulated away from political interference, and where you have a government that says, take the Anti-Corruption Investigation Bureau and have nothing to do with it as Attorney General. Give it to the Trinidad and Tobago Police Service and keep your distance from them. You see, what we intend, Madam President, what we intend is to remove the systemic blocks, remove the political connections, remove political appointees such as attorneys general appointed in the fashion that our Constitution allows, and let law enforcement itself do the work in an improved and expanded judiciary. I welcome the contributions of all honorable senators today. We look forward to any improvements that may be necessary to the legislation, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled, An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the Recovery of Criminal Property through the use of the remedies of restriction in dealings with civil assets, restriction and forfeiture of criminal property, and the management of criminal property, and unexplained wealth orders and matters incidental thereto, be now read a second time. Honourable Senators, at this stage, we will revert to item 8 on the order paper. Senator Mark.
Thank you. Thank you very much, Madam President. To the Honourable Minister of National Security, in light of reports that a Venezuelan national is in possession of a false Trinidad and Tobago identification card, can the Minister indicate what is being done to address this situation?
Minister of National Security.
Thank you very much, Madam President, and to the members for allowing me the indulgence of answering this question at this time. As stated yesterday, I have asked that this particular incident be comprehensively investigated. The Election and Boundaries Commission has very quickly ascertained that the purported Venezuelan is not entered on the Election and Boundaries database. I remind the population that as soon as this government announced that it would be having a registration process of Venezuelans, the opposition began their Cambridge Analytica playbook technique of saying that the EBC should not be involved in registration process. Madam President, I use this opportunity to state for the umpteenth time, this is not so. The Election and Boundaries Commission has nothing to do with the registration of Venezuelans. The registration cards that will be provided will not in any way resemble our national ID card. The registration of Venezuelans is a national security issue. From time to time and from time immemorial, documents have been falsified, not only in Trinidad and Tobago. We recently had another ally country of ours reach out to us about the falsification of passports, their passports, that were being surfaced in Trinidad and Tobago. This is a criminal act, and if it is ascertained that this social media mischief contains any act of criminality, it will be prosecuted by the Trinidad and Tobago Police Service. Any person found in Trinidad and Tobago with false documents, including birth certificates, ID cards, passports, driver's permits, or any other form of identification that is determined to be false, will be prosecuted by the Trinidad and Tobago Police Service.
Senator Mark.
Yeah, Madam President, through you. Can the minister indicate what time frame this investigation will take and whether the results will be published and made available?
Minister.
Madam President, this is a criminal investigation. So I will not prejudice the outcome of this investigation. I certainly won't fall into that trap because the whole country knows where the source of this social media mischief came from yesterday. So I'm not going to give anybody a get out of jail card.
Senator Mark.
Madam President, can the minister indicate, given the fact that the EBC has indicated that its database has not been compromised, what assurances can the government give to the country that free and fair elections will be held in this country for 2019 and 2020?
Senator Mark, that question does not arise, and I will not allow it.
You'll have free and fair election.
So, honourable senators, we will now revert to the debate on the bill. Senator Mark.
Thank you very much, Madam President. Madam President, first of all, I would like to, in dealing with this bill, popularly referred to as Unexplained Wealth Bill, may I, first of all, record our appreciation for the excellent work executed by the Honourable Leader of the Opposition by ensuring the insertion of several amendments to the current bill that is before us, which is revised and amended, aimed at improving its general framework. I want to indicate, Madam President, that firm commitments were given, and they are on the Hansard record, by the Attorney General, that all outstanding amendments that were not addressed in the other place will be addressed in the Senate. And I give him the assurance that we intend to pursue all those outstanding amendments today or tomorrow. And therefore, as we pursue this matter before us today, let me say, Madam President, that in a democratic society that observes the rule of law, depriving citizens of privately owned assets is a highly intrusive act on the part of the state. This conflicts and collides with several provisions of our Constitution, inclusive of the sanctity of property ownership, freedom of citizens from unnecessary interference by the state, and the right, Madam President, to privacy. Therefore, what we are witnessing before this honorable Parliament at this time and Senate in this legislation is what can be described as a radical departure from well-established norms and principles of fundamental justice. Therefore, we say from the outset that this departure, as it relates to well-established principles, is highly dangerous and disturbing. Madam President, I want to say from the outset also that in this jurisdiction, unlike others, the Constitution is supreme and not the Parliament. So the Parliament can pass any law, but the judiciary is there to interpret law. And therefore the Constitution, unlike the United Kingdom, that does not have a written constitution, is supreme in our instance. Madam President, apart from several draconian provisions that are contained in the legislation, I want to bring to your attention very early on this Honorable House that the onus of proof in this legislation has been reversed. It is using what is called the civil standard, known as the balance of probabilities, on reasonable suspicious grounds, to determine whether the defendant or the respondent can lawfully prove that the wealth he has in his or her possession was lawfully acquired in relation to its size. What is also disturbing in this legislation is its retrospectivity. The legislation goes back to slavery and indentureship because there's no timeline outside of tax crimes. So it could go back to slavery and indentureship. So we are going after the planter class, as well as those the AG and the government seem to be emphasizing or placing emphasis on, the ordinary youths on the block who have blings, gold chain, and cars. I want to make it very clear, Madam President. Those who have unexplained wealth in this country, which is disproportionate from their earnings or their capacities, we have no problem. Let them explain. Because it's not only ordinary people from Silox and John, and in parts of Trinidad and Tobago are in that category. There are a number of jacket and tie people in this country who have to explain their wealth. So this bill is not only targeting the ordinary people, it is targeting the rich and the planter class former. So I want to make that very clear. Madam President, what I would also like to bring to your attention is that under our Constitution, an individual is innocent until proven guilty. Under this draconian legislation that is before us, they have reversed it. They say, you are guilty, Madam President, prove your innocence. That is a fundamental departure from our Constitution. That alone is grounds for the government to revisit this legislation. Madam President, what is also important on this matter is this. Citizens are going to be called upon to self-incriminate themselves. Again, that is protected by the Constitution. You cannot self-incriminate. And the provisions in this legislation is calling on you to self-incriminate yourself. And Madam President, the other area I wish to bring to your attention is the matter of the separation of powers. And the collision that I am seeing in this legislation between the legislature and the judiciary, and the overreach of the executive vis-à-vis the judiciary. Madam President, I will demonstrate as I proceed where both the Mendoza factors as well as what is called the Engels factors in the United States jurisdiction and the European jurisdiction, respectively, come down clearly on provisions and conditions that must be satisfied to determine whether a matter is civil or whether a matter is criminal. And what we are doing in this legislation is marrying and intermingling both the civil with the criminal. And that is dangerous. We must be clear, Madam President, that it is either criminal or it is civil. Don't try to confuse the judiciary and don't try to confuse this Parliament in this particular respect, Madam President. Madam President, there are many cases, as a non-lawyer, I want to bring to your attention because they are very interesting cases, rather. I will refer to them as I proceed on this particular matter. Madam President, it is clear that on the basis of suspicion, an individual who is not charged, although they would fall under the second schedule of the Proceeds of Crime Act, I will show to your good self and the Senate where under 45, Section 45, or Clause 45 of the legislation, where, Madam President, you don't have to be charged. Somebody will just decide whether or not you have done something or have something that is suspect to be rooted in criminal conduct or an instrumentality of crime or acts of terrorism. Somebody just only have to, in their opinion, determine that. There's no basis in law. There's no principles, or there are no principles that are guiding whether something is of a criminal nature or of a civil nature. But I have documentation, as I talked about the Mendoza factors and the Engels factors, both from the United States and Europe, that says clearly that if you have to determine whether a matter is of a criminal nature and therefore, or beyond a reasonable doubt, must be employed, or whether a matter is of a civil nature, you can deal with balance of probabilities and just suspicion. That is the conundrum, Madam President, that we have to resolve in this legislation. And I believe the first person who is charged under this legislation they will take it to the courts, right up to the Privy Council. And I'm sure, given the hard, entrenched provisions, Madam President, I looked at Australia, and I was shocked to learn that in Australia, there is no entrenched Bill of Rights. So the Australian people depend on what is called common law principles to uphold their rights. In Trinidad and Tobago, fortunately, the founding fathers of this nation entrenched a Bill of Rights. So we know all our rights in Trinidad and Tobago. And nobody can come and just take away those rights easily and whimsically, Madam President. I have always argued, Madam President, those who do the crime must do the time. But I prefer 8 guilty people to go free than 1 innocent person found guilty. That is my position on this piece of legislation, Madam President. Madam President, there are provisions, and I refer immediately to Section 33, subsection 5 of the legislation, where you can proceed under the civil asset forfeiture regime. Go to the court without notice, ex parte, as you would call it, Madam President, in law, and make an application. And if you are lucky to get through with that, Madam President, then you get a freezing order, as we are told, on your properties. But here we're talking about property in rem. So a property has life now, you know. Property must explain how it came about. No persons behind the property. Only when we come to what? Unexplained wealth. Then you put in a human being behind the property. Madam President, this law, both in 33.5, which we are going to make it very clear, there should never be any provision in this legislation for ex parte excursions. Because you are dealing with property rights, Madam President, and privately owned assets, and because you are reversing the burden of proof from what exists in our country, from one of being innocent until proven guilty, to one where you are guilty and you're called upon to prove your innocence, Madam President, we are saying in every section of the legislation where there is a provision for ex parte hearing, we are proposing every provision must be inter parties and not ex, Madam President. Meaning that you can go on your own and do your own thing, Madam President. Madam President, you would also be aware that under our jurisprudence, there's a famous saying, he who alleges must prove. You are making allegations against individuals, and you are telling those individuals, after you make those allegations, prove your innocence. Madam President, not in a democratic society that has respect and rights for the fundamental rights and freedoms of our citizens. That can take place in a fascist state. That can take place in a state where they don't have a Bill of Rights. But in our country, we have a Bill of Rights. And therefore, you cannot go down that route, Madam President, so easily as is being attempted by the government. And I will show you how, in the hands of wrong individuals, how it could be manipulated to be used, as my colleague said, the Attorney General, as a nuclear weapon. But it will not be a nuclear weapon against the blingers and the zesters. But it could be a nuclear weapon against politicians, rivals, opponents, and so-called enemies of the government. Any government can use this legislation in an arbitrary fashion in order to get at their political opponents. So, Madam President, hear what we are saying. We are saying that the government ought to know that the standard of proof in civil matters is balance of probabilities, and we know they know this. And they have said that in the legislation. But what they also know, Madam President, is that the standard of proof when it comes to criminal matter is that it must be beyond reasonable doubt, Madam President. And in the legislation, we are mingling and commingling civil matters with criminal matters, Madam President. So where do we end? And Madam President, what is worse? There are no guidelines in the legislation to guide us as what they did in Europe and the United States, Madam President, on the Mendoza factors as well as the Engels factors. So, Madam President, as I said, there is a collision between proceedings that are civil and proceedings that are of a criminal nature. Now, the government has introduced, Madam President, and has referred to the Proceeds of Crime Act and says that that is the number of offenses that would be addressed in the legislation. I think it's about 20 or 21 of those offenses that will be addressed, Madam President. But, Madam President, I would like the Attorney General to tell this country what are the true boundaries between proceedings of a criminal nature and of a civil nature. What are the boundaries? Because we are saying, Madam President, in this legislation, that the standard of proof is the balance of probabilities throughout the legislation. But we are also seeing in the legislation where people can be charged under the Proceeds of Crime law under Schedule 2, and there are 21 offenses, all of a criminal nature. So the government is commingling criminality with civility and telling us in Trinidad and Tobago that this act, this bill, is proportionate. How this bill could be proportionate? It is disproportionate. Because the evidence is showing that this bill, in its current form, has to adopt the criminal standard and not the civil standard. And therefore, we must deal with matters beyond any reasonable doubt, and not to gamble and play footsie with people's fundamental rights by saying that this bill is subject only to civil proceedings, and civil proceedings mean a standard which is known as balance of probabilities. And when you translate that, it means reasonable suspicion. No, that is not acceptable, Madam President. We will make amendments to ensure that the reasonable, beyond any reasonable doubt, is inserted in the legislation. And we have many more amendments to make, because none were made to the third part, and none was made to the fourth part. Because of why? They are time constraint. We have none. We could work Easter Sunday here. We have no time constraint. When you're dealing with the rights of the people of our country and innocent people being taken down the chute, we cannot compromise on this question, and time should not be a barrier whatsoever, Madam President. So, Madam President, as I said, you look at this section very carefully, and you will see where, and I want to quote, if you join me, in section 45(2) of the legislation, where it says, Madam President, that property which is described as criminal property, it is not necessary to show that the property is derived directly or indirectly, in whole or in part, from a particular offense, or that any person has been charged in relation to the particular offense, only that it is criminal property. So, Madam President, what they are saying in 45(2) is that you don't even have to be charged. The government is giving the police and the Comptroller of Accounts, Comptroller of Customs and Excise, rather, and the Chairman of BIR to do their investigation. Then they go across to the DPP, who under Section 90 of the Constitution can only deal with criminal matters. He can start, he could initiate rather, he can discontinue, or he can proceed. Continue, Madam President, start, discontinue, or he can. So he has three, but that is the end of his remit. But in the legislation, the DPP is commingling with civil matters and criminal matters. How can that be proper, Madam President? I want to tell you, Madam President, let the Attorney General tell this country what are the true boundaries between civil proceedings on the one hand and criminal proceedings on the other, Madam President. Madam President, you will know in the legal literature, and the government made it very clear today, the aim of this thing is to take money out of crime. They want to punish people. When they punish people, they're not returning property to anybody. It goes to the state. So it's a revenue-raising mechanism. The government is strapped for cash. So they are going to raise revenues from this measure. But, Madam President, if you're going to raise revenue out of this measure and you're going to punish people as a result of this measure, then, Madam President, let us deal with the legislation properly. It is of a criminal nature. And therefore, deal with the criminal standard, Madam President. Madam President, we believe that this legislation in its present form is constitutionally invalid, and I believe an absolute repugnant to the judicial process in our country as we have grown to know it. Madam President, I want to tell you, in the United States of America, there are two matters that I would like my colleagues, just as how the AG said he has looked at matters and he'd like members to look at it. I have two matters, two cases that I've looked at as a non-lawyer. Timbs, T-I-M-B-S versus Indiana, Supreme Court of the United States. I would like members to look at this case. Because this is a case, Madam President, where I will give you an example before I close, where if you go to Sealots and you see a man with a gold chain, he bought it in Guyana, I am assuming, or it is alleged, and he paid $5,000 US for that chain. They seize it here because they say you can't explain your wealth. You're living beyond your means. And they get their experts, the government expert through the agency, to value that chain. And they say that chain is valued at $20,000 US. You know what it means in this legislation? It means that you have knowingly and recklessly misled and provided false information to the agency and its personnel. You know what it means, Madam President, under the law? It means $100,000 or 20 years in jail. That is what it means, Madam President. You're taking away people's liberty on the grounds of a mistake. In the United States, Tim versus Indiana, the man got monies from his father via an insurance when his father died. He bought an SUV for $42,000. They charged him for a crime valued at $10,000. They seized the man's Land Rover and said that Land Rover was being used to transport drugs, which they captured and they valued at $10,000. The Supreme Court of the United States in Timms versus Indiana said it is unconstitutional. It is disproportionate, Madam President. Madam President, so that is one case members of this Honorable House need to look at to show the disproportionality of the legislation. Madam President, there's a case called Boyd versus United States of 1886. And a similar situation went on there, where they demanded, under the legislation that was passed then, that this gentleman who was a defendant produce in court his private books, invoice and papers, or else, Madam President, he gone. Well, look, they demanded that. He took them to court, and the court upheld that it was unconstitutional and voided the entire process. This is Boyd versus the United States of America. It tells you, Madam President, that no government has the right to make the kinds of demands on a private citizen if you are not using the criminal standard beyond all reasonable doubt or beyond a shadow of a doubt. Don't come with legislation, Madam President, and we are proposing a preamble. I want to put the government on notice. We shall be providing and advancing an amendment to insert a preamble into the legislation that calls for a 3/5 majority. You want to reject it? You reject it. But we are saying to safeguard this legislation, if you're serious, put in the 3/5 certificate to avoid any challenge in the courts. Madam President, I'm not telling you, I'm advising you that the first person who is held under this legislation, when it is proclaimed, they will take the government and the AG to courts. And this act, which we are critically identifying with today, will be struck down as unconstitutional, illegal, and null and void. That's the second case I want to bring to the attention. Madam President, Professor Anthony Gray, a distinguished professor from Australia, he did a piece on something called the compatibility of unexplained wealth provisions and the civil forfeiture regimes with cable. Cable is a doctrine, Madam President. Cable is a doctrine involving a case in which it was proven, Madam President, that if you do not have that standard of beyond a shadow of a doubt, and you use the ordinary balance of probabilities, you are tampering and invading people's rights and liberties, and that is not permissible. And in this particular scholarly document, he made it very clear, Madam President, this is a situation in which he outlined the Mendoza principles here. He outlined the Engels principles, and he said that when you weight this measure of asset forfeiture, this provision of unexplained wealth in the Australian law that the Honourable Attorney General referred to, he made it very clear, Madam President, that they are of a criminal nature, and therefore a criminal standard is needed, and not on a balance of probabilities, as we are being told here. And on what? Reasonable suspicion, Madam President? That is what we are being told, Madam President. So these are three measures I would like colleagues to look at, Madam President. Madam President, when I looked at the part in the legislation that deals with what is called unexplained wealth, Madam President, I want to tell you, the last time I did a research, the last research that was done on wealth distribution in this country was sometime in 2009, 2010. The situation has worsened since we left office. 1% of the population controls 70% of our wealth. 1%, according to a research paper that was done by the United States. I can't remember the name of it. They estimated 1% controlling 70% of the wealth. But you are coming with legislation to go after who, Madam President? I haven't heard the AG mention anything about the planter class. I haven't heard the AG mention anything about the bourgeoisie in our country. All the AG and the government is concerned about are those people with bling and gold chain and fast cars and BMW. So the message is this legislation is directed at those people. It is not directed at those people in jacket and tie, Madam President. Madam President, I want to bring to your attention. It's a book that I read years ago. 2 books. Charles Dickens, A Tale of Two Cities. And the other one is Mark Twain, The Prince and the Pauper. This legislation is Sealots versus St. Clair. I break down this legislation to one of Sealots versus St. Clair. And therefore, anybody in Sealots who have a gold chain will now be under suspicion. And the police will come after them because they just suspect. Nobody, as far as I know, in Sealots have been jailed yet or have been charged yet. But this legislation is saying, Madam President, on suspicion, you'll be charged. But you know, there are people who have properties in St. Clair. And I have read and I have the research on it, Madam President, where there's a building somewhere in St. Clair where, for instance, Madam President, a landlord charged this country a large amount of money to rent that building. And when we looked at and we did our research, we saw something being advertised on the internet for that same building, which was $200,000 less than what we have been asked to pay in Trinidad and Tobago. So this legislation, Madam President, when it takes into effect, or it comes into effect, that landlord in St. Clair must be the first one to explain his wealth. Must be the first one to explain his wealth, because we'll have to seize that property. Madam President, let us be serious now. Everyone is entitled to the protection of the law in this country.
Senator Mark, you have 5 more minutes.
Thank you, Madam President. Everyone is entitled to the protection of the law. Everyone's entitled to the enjoyment of property, which is family. Everyone is entitled, Madam President, to be, if you're charged with a criminal offense, you are innocent until proven guilty. This is criminal legislation. I defy the Attorney General and his government to tell Trinidad and Tobago this is civil type legislation. This is criminal type legislation. But what the Attorney General and the government is doing, Madam President, is trying to almost mesmerize us. They are trying to confuffle us. They are using civil standards in the legislation when all the offenses are of a criminal nature. And I am telling you, Madam President, I have done the research, and I'm saying this is bad law. We cannot support bad law. But because, Madam President, the AG made some little tinkering with the legislation in the other place, the Honorable Leader of the Opposition also made improvements, and we supported it there. I'll tell the AG something. We will support it here as well. We will support it. Highly critical support. Highly critical support. But I want to tell the AG, even though we are going to be supporting the legislation, I am warning the AG that once this bill becomes law in this country and the first citizen challenges this bill and this law, it will be struck down as being unconstitutional. And this is why, Madam President, we have made it very clear that we are proposing several amendments. If the AG wishes to reject it, it is his right to reject them. We are putting a preamble, a certificate for a 3/5 majority with the appropriate changes to the legislation. If they want to reject it, that's their business. But at the end of the day, Madam President, the people will see what this legislation is really all about. So, Madam President, I want to say in closing that the AG was very short on focusing on white-collar criminality in this country. I have read extensively contributions in the other place. And, Madam President, every person who would have spoken in support of this legislation on the government bench seemed to be obsessed with what is called the blingers, the zesters, or the zesters, as they call them, and those ordinary people from Sealots and John and other places. Madam President, if the government wants to fix this place and deal with crime and to deal with its escalation, its responsibility, Madam President, its first responsibility is to ensure that there is increased production and output of goods and services. They must ensure that there is equity in the distribution of resources in this country, and they must reverse the inequity that exists in Trinidad and Tobago between those who have and those who don't have. Don't bring legislation to further enslave the poor and the oppressed. It seems like a pattern, Madam President. The government is developing a pattern where they are bringing legislation to handcuff, to arrest, and to incarcerate the ordinary people of this country. And as I close, Madam President, let me close by telling you and this honorable House, anyone who does the crime must pay. They must pay. They must do the time. But I'm saying don't let this law be inequitable. Go after the planter class. Go after the bourgeoisie. Go after St. Clair. Go after all them rich people who we don't know how they gain their wealth. Madam President, in closing, there is a particular family that you may not be aware of, but we have done the research. They own 250 properties in Port of Spain. They own the whole of Charlotte Street. Madam President, how did this family accumulate this kind of wealth? Billions of dollars involved. I think the AG is familiar with those people.
Senator Mark, your time is up.
Thank you very much, Madam President.
Vieira.
Thank you, Madam President. Madam President, it will be difficult to do full justice to this piece of legislation, which is 88 pages long and the size of a small book, in the time that we have. But let me assure my good friend, Senator Mark, that this legislation is a nuclear weapon in the fight against the white-collar criminal. This is particularly targeted to the jacket and tie St. Clair Morida. It is criminal legislation, but not in the sense, I believe, suggested. The philosophy behind this legislation is recovery of property, money, and goods unlawfully obtained. There's a saying, thief from thief make God laugh. And I think that's what we're dealing with here. It will also lead to the identification of criminals. Now, the Attorney General started off by saying that this is a most important bill, and he's absolutely right. This marks a very serious departure from our law.
because generally, while we have seizure and forfeiture provisions throughout our laws, they usually follow from a criminal conviction. What is significant here, the big game changer here, and what makes it a nuclear weapon for law enforcement, is that it reverses the burden of proof. It requires the respondent to reveal the sources of his unexplained wealth or lose it. Now, is this legislation necessary? In the UK, the unexplained wealth orders started coming about because people became aware of the presence of foreign wealth, in particular, the wealth of Russian oligarchs who are buying up all the key properties in England. And they wanted to bring a handle on it. It was very difficult to be able to act just on suspicious wealth. We have a similar problem in this jurisdiction. We see a lot of people who have all kinds of properties and driving all the fancy cars, seeming to be doing very well, but there's a disconnect between what they earn and what they have. And so it is very necessary to try and guard against that type of undermining of our economy. Because as we all know, white-collar crime is both costly and dangerous to society. And it is also extremely difficult to apprehend and to prosecute. But I agree with Senator Mark. This kind of legislation, we have to interrogate very, very closely. We have to ask ourselves, does it pose a threat to the average honest citizen? And does it pose a threat to political dissenters? Because it is so potent, we have to guard against these risks and the potential for abuse. And I will treat with that in some detail as I go down. How does this bill work? It works by creating some important posts. In particular, the civil assets trustee, the property manager, the civil assets recovery and assets management fund, and the civil assets recovery and management agency. Now that agency will be a body corporate, and it will employ staff, experts, advisors, and consultants. So this legislation is in fact creating an entire ecosystem which will have the necessary acumen and expertise, and it will, I suspect, be a very expensive undertaking. Now, how does it work? There are really three gears: explain, freeze, and seize. The process is as follows, as I understand it to be. The police will forward an investigative report to the DPP because they suspect recoverable property. The DPP, if he thinks that there's not enough to secure criminal conviction, but he thinks that there is recoverable property, suspicious property, will refer the matter to the agency. And then the agency, through the civil assets trustee, will apply to a court. And then the court, if satisfied on the balance of probabilities that there's reasonable grounds for believing that the assets are criminal property, can do a number of things. The court can freeze bank accounts. The court can direct the agency to take possession of the property. And the court can also bespoke the order. So, for example, by excluding parts of the property and providing for the owner's living and legal expenses. And of course, if the respondent can give an explanation, and again, that explanation is satisfying on a balance of probabilities about his interest in the property and how he got it, he keeps the asset. It's only if he is unable to give a satisfactory explanation that he suffers the possibility of losing it. The legislation allows for interested persons to apply to vary or set aside the court orders, and the burden of proof is lower than what would obtain in criminal proceedings. The legislation also allows for dealing with perishable items. Now, I should point out that seizure and forfeiture already exists in our law. In the civil jurisdiction, we are well accustomed to Moreva injunctions and Anton Pillar orders. But we also have seizure and forfeiture provisions in the criminal and administrative jurisdiction. In the Trademarks Act, there's a general power to order forfeiture of goods, materials, and the articles by means of which the offense was committed, Section 66D. And forfeited goods are generally destroyed, but the court has a discretion, instead of destroying the goods, to release them on specific conditions. So, for example, to an orphanage or to some charitable purpose. The Copyright Act. Under the Copyright Act, the police have power to enter and search property, planes, vehicles. And the police have power to seize, remove, and detain any article which appears to be an infringing copy. Section 45. And again, the court can order destruction of the goods, but the magistrate has a general discretion to deal with the goods otherwise. Again, if there's a way to give it to charitable purposes, and so on. Under the Trade Descriptions Act, where a person is found guilty of committing an offense, is liable to forfeit to the state every chattel, article, implement, or thing by means of or in relation to which the offense was committed. And of course, under the customs legislation, the controller of customs has considerable power, important powers in relation to the seizure and forfeiture of infringing goods. So this is not new. What is different, though, is this reversal of the burden of proof. And now to deal with the checks and balances. Because I think every citizen needs to be assured that this is not legislation that is going to be used oppressively. People who are engaged in political activities need to be assured that this is not something that is going to be used to clip them or to intimidate them or to harass them. First of all, the agencies are body corporate. So it's not a government department. It doesn't come under any minister, any ministry supervision. The civil asset trustee must be a lawyer of at least 10 years standing. And this person is appointed by the president, as we all here are on the independent bench. The president appoints on the advice of the Judicial and Legal Services Commission, and importantly, the president can revoke at any time that appointment. The deputy trustee is a lawyer of some 10 years standing, again appointed by the president, but this time on the advice of the prime minister and the leader of the opposition. The property manager takes control pursuant to high court orders and answers to the court. And he has some very important statutory duties set out at clause 72. Everyone is under a very strict duty of confidentiality. So, who are the players in this ecosystem? The president, the police, the director of public prosecutions, the high court, and an independent, stand on its own agency. I am satisfied that those are sufficient checks and balances in place to avoid any suggestion or attempt on the part of government to use this oppressively. I come now to the unexplained wealth orders. Well, over the past 30, 40 years, we have seen untold wealth. Inventors, writers, financiers, and entertainers. People like Gates and Jobs, Rowling, Warren Buffett, the Kardashians. And we celebrate their achievements. But when there is wealth for which there is no discernible source, that must be a cause for concern. Dirty money, and especially dirty money as identified in the second schedule of the Proceeds of Crime Act, participating in an organized criminal group and racketeering, terrorism, trafficking in human beings' body parts, sexual exploitation, trafficking in drugs, arms trafficking, corruption and bribery, fraud, counterfeiting, environmental crimes, kidnapping, robbery, theft, extortion, piracy, forgery, insider trading and market manipulation. These are the white-collar criminals. Well, that is an affront. That kind of money is an affront to decent, hardworking people. And if we are serious about taking the fight to the criminals or removing the proceeds of crime that allow them to live off other people's misfortunes and hard-earned wages, we need this law. This law will give the authorities a chance to target wealth linked to suspected criminality held in banks as well. It will make Trinidad and Tobago a hostile environment for money launderers. Now, how does the unexplained wealth order work in practice? Again, is this something that can be used by people in government to harass or intimidate citizens and political dissidents? Well, look at how it's initiated. It's initiated by the Commissioner of Police, the Chairman of the Board of Inland Revenue, the Comptroller of Customs. And how? Where, during the course of an investigation, there appears to be a disconnect between what a person has and what a person earns, where he has over $500,000 in property, property owned by or under his control, or where property appears to have been obtained through crime. They make an application to the High Court, which then requires the respondent to explain. So it doesn't just go, none of them have the power to do the huffing. You go back to the independent court. The court gives the person an opportunity to explain his source of wealth, and then the appropriate orders are made. These powers are activated when the investigator suspects and the court is satisfied that the money identified is the result of crime. Now, there's a lot, as I said, in this legislation because it sets up a whole ecosystem, but there were some points of note. One is the in personam and in rem at clause 6. Well, as the AG has explained, in personam, which tends to operate generally in litigation, an in personam order is directed specifically at a particular person. And that doesn't make sense when you're dealing with property where you want to have the whole world to know what is going on with the property. So that's why the orders are made in rem, because in rem it means that the rights are enforceable against the world. What it also means, too, I think, is that the law-abiding citizens now need to be more conscious of keeping their receipts and being able to have the right paper trails in explaining how you have your assets. But I mean, most people do that. They have insurance. They keep things of that nature. Keep your receipts for expensive jewelry, because in other jurisdictions, we have seen where, in one particular case in England, it was a very expensive ring that was the object of the unexplained wealth order. Now, one of the, I don't know if you want to call it a downside, But if this law does become operationalized, it may mean that we will see a decrease in certain types of money flowing into Trinidad and Tobago, because the appeal for illicit income flowing into Trinidad and Tobago will be, I think, lessened somewhat. But on the upside, Minister Khan has often talked about the ways in which the state earns money, and they're very limited. But this may be yet another opportunity, another bow, another arrow in the sheath of the state to earn, to acquire assets and property. So the state, the public, and charities hopefully will benefit. Another important aspect of this was Clause 68, which allows the Attorney General to operationalize mutual assistance treaties and to work with countries in identifying and going against recoverable property. We've had situations where we know of our money and assets ending up in Panama or in Toronto, Canada. This law will allow the Attorney General to pursue the assets in those countries. The agency. But I think the clause is that the AG must operationalize the treaty, and it works under the Mutual Assistance Treaty. Thanks. Now, one of the things I was concerned about, and it's not too strong in the legislation, and I suppose the knee-jerk reaction is to say, well, you always have a right of remedy in the court. But what happens where property rights are wrongfully intruded upon? Well, I think compensation should be payable. Yeah? And preferably in the same proceedings. Because after you've gone through the agony of having to explain, waiting for your explanation to be accepted, to then go and bring fresh proceedings, and I think that could be unjust. So I would like, perhaps maybe in the form of a show cause application in the same proceedings, that you can apply for your compensation. Under the Customs Act, for example, there's provision for the court to order an applicant to pay the importer, the consignee, and owner appropriate compensation for any injury caused to them through the wrongful detention of goods. So I think that is certainly a suggestion that I would make. So in wrapping up, I would say, yes, it's true, the Constitution protects persons and property, but it also allows for law enforcement. This is important legislation. It's going to be important in the battle against crime, and in particular against white-collar crime. And with those few words, I thank you.
Senator Simonette.
Mr. Vice President, I thank you for the opportunity to contribute to the debate on this very important bill entitled An Act to Provide for the Establishment of the Civil Asset Recovery and Management Agency for the recovery of criminal property through the use of the remedies of restriction in dealings with civil assets, restriction and forfeiture of criminal property, and the management of criminal property, and unexplained wealth orders and matters incidental thereto. Mr. Vice President, this bill is a critical bill that aids the law enforcement initiatives against all manner of crime, white collar, black collar, trafficking, terrorism, and the list of crimes outlined in the schedule to the Proceeds of Crime Act. It is very correct that it is described as nuclear, but that is not a new term when appreciating that the remedies in this Act are analogous to preemptive remedies known to commercial civil law litigators going back to the 1970s and the onslaught of the interlocutory applications and preemptive remedies of the Mareva injunction and the Anton Pillar order. Indeed, Lord Hoffman, in commenting in the foreword to the leading text by Stephen G. QC on Mareva injunctions, had this to say about the jurisdiction as it developed in the civil arena at that time. In describing the result of the work that led to the run-up to the development of the jurisdiction, he indicated that the result of the work and the work by Stephen G. deals comprehensively with a subject which did not exist before the mid-1970s and which probably represents the most remarkable example of judicial creativity in this century. And the objective of that judicial creativity, Mr. Vice President, was to find a remedy where the courts would take appropriate steps in appropriate cases to try and ensure that judgments are not rendered valueless by an unjustifiable dissipation of assets. And that is the focus in what the said author, Stephen G., describes as the criminal Mareva injunction, which, with respect, I urge those reviewing this legislation to adopt. Because what the bill captures, and I dare say captures, having addressed all the maladies of the civil asset forfeiture jurisdiction worldwide, is the ability to deploy civil forfeiture remedies to assist the criminal arena. And there is no aberration in that approach. I think that Senator Mark is perhaps a little ill-informed of the range of jurisdictions worldwide that have come to use and to observe the efficacy of the civil law aiding in the administration of criminal justice. And that brings me to the structure of the applications for both orders under the legislation, property restriction orders, as well as the unexplained wealth order, and to address frontally the concerns raised by Senator Mark on the procedure called the ex parte procedure. Again, for the listening public and those who are not lawyers, the Latin ex parte simply means without the other side having being at the first hearing. It's now called a hearing without notice under our civil procedure rules. But the reason for the provision and for the ex parte process is precisely the ability to defeat the fundamental objective of preserving the assets and ensuring that those assets are not frittered away and put beyond the reach of lawful forfeiture. So that the application which is made in the first instance without the other side being present is for a specific purpose and a practical specific purpose of maintaining the status quo, which we lawyers know as preserving the very property that law enforcement is attempting to secure under the legislation. It is not a denial of rights. It is simply a technique in appropriate cases, and judges of our courts have dealt with the ex parte jurisdiction for many, many, many years. And those making the application, of course, are well advised to comply with the fundamental duty to make full and frank disclosure of all matters that they have investigated and that are relevant to the application under process. What then follows the ex parte application, assuming that the applicant, in this instance, as we know, it is the agency, Civil Asset Recovery Management Agency, who makes the application following the intervention of the DPP, who refers appropriate cases to the agency, so that the filtration points are well structured to sift any kind of abuse or any kind of interference. As we all appreciate, as trite law, the DPP functions independently under our Constitution. Prior to his intervention, as we learned, there are three officers or three senior people who, in different areas, are required to make appropriate investigations. The Commissioner of Police, the Controller of Customs and Excise, and the Chairman of the Board of Inland Revenue. And again, it is important to focus or to understand the relevance of the intervention of the Chairman of the Board of Inland Revenue. It is not correct at all of Senator Mark to misguidedly endorse or underscore that this legislation is aimed at the poor man or the little man and not at the planter class. Tax evasion is often the practice of fairly sophisticated and substantial persons in society. And so the capture of tax evasion and fraud relevant to proceeds of crime answers the question or answers the allegation that somehow this government is focused only on the small man. So that coming back to the balance and proportionality of the process, following the ex parte order, certainly for the property restriction orders and the preliminary unexplained wealth orders, and I'll come back to the preliminary unexplained wealth order, the respondent is afforded an opportunity to put its case at an inter partes hearing, and that is a hearing where all concerned are present. And the bill provides for notice to be given to all relevant parties and to afford them an opportunity to be heard, so that there's no denial of justice, there's no attempt to remove the sacred right to a fair hearing or to be heard, or, as it were, to access justice under this Act. Following the inter-parties hearing, the order is either made for a forfeiture order, or it may be varied or discharged. And indeed, in respect of third-party rights, again, the classical Mareva jurisdiction is employed, and the Act provides for treating with third-party rights in respect of interests that exist relevant to the property, where such interests need to be taken account of by the judge. And our judges have had long experience of dealing with and balancing these rights in circumstances such as this. So that the introduction of the criminal Mareva under this bill is not an entirely new body of legal jurisprudential treatment, having come out of what is the well-worn Mareva and Anton Pillar preemptive remedies available in civil proceedings. If the property restriction order, which is ordered to last for no more than 90 days before it is visited in a full inter-parties hearing, is made a final order, then the final forfeiture order removes the legal ownership of the relevant property and vests same in the state. Of course, as was pointed out by both Senator Vieira and the Attorney General, along the way, and again harking back to the Mareva jurisdiction, respondents are afforded proper access to their monies in respect of legal fees and representation, including the reasonable living expenditure and inclusive, where appropriate, of education expenses for children and the like. And that is a well-known aspect of the similar jurisdiction in the United Kingdom under the earlier legislation in this area of forfeiture of assets and property and the like that flow from the proceeds of crime. Again, with regard to specific items of property, the bill treats with how disbursements and expenses of such property, for example, in relation to land, the payment of relevant loans that are secured on land, as well as the payment of rates and taxes. With regard to property constituting equities, gilts, shares, bonds, etc., of course, the agency is required to obtain an equity valuation of such shares and property. Where assets of the nature of boats, cars, and planes are the subject of an order, of course, the agency, in the form of the property manager, has a duty to ensure that those assets are properly maintained until final order for disposal of the assets. We then come to the unexplained wealth order, which, with respect, comprises a new and innovative element for attacking especially money laundering and white-collar crime, in my respectful view. This order, or this weapon, requires the respondent to explain how his total wealth exceeds in value wealth that he can demonstrate is his lawful wealth. And that regarding relevant property he owns or controls. The process starts, of course, and unsurprisingly, with a preliminary ex parte application for a preliminary unexplained wealth order. And what the preliminary unexplained wealth order permits is for the applicant to request an order of the court which requires the respondent to file a disclosure declaration explaining the difference between his lawful wealth and the value by which that lawful wealth is alleged to exceed, value by which his actual wealth is said to exceed his lawful wealth. And again, civil commercial litigation lawyers are well aware of the Norwich Pharmacal type application and order where you seek disclosures of information in a relevant case prior to actually proceeding to the full trial of the cause under prosecution, that is civil prosecution. Again, in a balanced and proportionate treatment, a respondent who is the subject of a preliminary unexplained wealth order can apply to the court to revoke the order within 28 days. And of course, that hearing would be inter partes. Of course, if the preliminary unexplained wealth order is upheld and an unexplained wealth order is made, then the effect of that order is to require the respondent to pay the unexplained wealth amount into the seized assets fund. Madam President, the Seized Assets Fund is created by the Proceeds of Crime Act. And again, it is interesting to weigh the manner in which such payments are to be treated with. Firstly, the unexplained wealth order, when made, constitutes a civil debt due by the respondent to the state and takes effect as a judgment debt. But the Seized Asset Fund is stipulated to treat with, in terms of the application of proceeds in the fund, a very interesting range of permitted expenditure. And Senator Diyal Singh will appreciate this. Firstly, applied to community development. Secondly, to drug abuse treatment. Thirdly, to rehabilitation projects. And, of course, later on, to meeting the cost of law enforcement. So that I certainly doubt very much whether, as Senator Mark agitates, there can ever be an allegation in Trinidad and Tobago of policing for profit. Our jurisprudential treatment of this area is dramatically different and improved upon how this has been dealt with in various states of the United States where that issue arose. And I repeat, there will not be in Trinidad and Tobago any legitimate allegation that this legislation will permit for policing for profit. Madam President, the strength of the legislation is also secured by the manner in which it treats with asset management. And of course, the post and function of the property manager is established with very detailed duties and obligations on him or her as to how he is to treat with property forfeited, seized, etc. Of course, of fundamental importance is that he must report to the High Court of Justice as well as to this Parliament and to the Attorney General. But his first order of compliance in terms of reporting is to the High Court. So that the framework of the Act, its design, its architecture, Madam President, is with respect balanced, well thought out, under settled judicial management in terms of all aspects of applications for orders under the Act. And accordingly, the risk of abuse, whether it be to the small man or whether it be to political dissidents or political opponents, has to be virtually zero, in my respectful view. And I say that because, as we know, in the civil jurisdiction on these ex parte applications and the like, the duties, the judge, presiding judge, is very careful to ensure that the material before the court supports the imposition of the court's powers where the other side at that point is not present. And Madam President, I know that you have yourself practiced in this area and would appreciate the solemnity of a judge's function on ex parte or without notice applications. So frivolity and vexatiousness will not be tolerated, and those are the classical terms used to weed out unmeritorious applications and unmeritorious cases. Again, the architecture of the agency itself, managed by attorneys with certain experience in finance, asset management, and the like, and of no less pre-qualification, post-qualification experience of 10 years, lends a degree of confidence to the view that the agency will be run in a professional and proper manner. Again, the role of the DPP, who will be the ultimate filter of investigative work by a reinvigorated Trinidad and Tobago Police Service, assures that the quality of the investigative work achieves certainly a standard that augurs well for there to be fairness and there to be virtually no injustice to the citizen. Madam President, I wish to treat with the reversal of the burden of proof that appears to be troubling to Senator Mark. It is well settled in the United Kingdom, and indeed in other Commonwealth countries, that the paramount public interest in prevention of crime and confiscation of the proceeds of crime justifies the placing of a civil burden of proof. Again, I believe Senator Mark misunderstood the process. The civil burden of proof not only applies to the applicant for these orders, but equally applies to the respondent who is called upon to justify or to demonstrate that his wealth or his property is legitimate property and legitimate wealth, not the subject of or the proceeds of any criminal activity. And that standard is the same standard as applies to the applicant, albeit in the civil jurisdiction, in the area of interim injunctions, the burden is indeed on the applicant to continue to demonstrate why the injunction ought to be continued. But I support the jurisprudence that says the paramountcy of the public interest justifies the reversal of the burden in this area. So that in closing, Madam President, I reject Senator Mark's call for elimination of the ex parte procedure. Indeed, to accede to such a call will fundamentally defeat the very objective of preservation of assets and ensuring that they are not dissipated. So that call must be rejected, root and branch, and out of hand. Again, I hope that the balanced and proportionate treatment of applications and of access to vary and or discharge orders made addresses the concern that there could be some capricious abuse of the citizen in this area. Madam President, the purpose of this legislation is salutary. It is necessary in aiding the work of bringing criminal conduct, all aspects of criminal conduct, to account and leading to the erosion and elimination of wanton crime in our society. It delivers the capability of enforcement against assets, money, and property generated by criminal activity, including the very significant activity of tax evasion. Madam President, I certainly endorse this legislation. And in closing, I wish to congratulate not just the Attorney General, but his staff and all the lawyers in the Ministry of Legal Affairs who have tirelessly worked on crafting what I consider to be perhaps the new beacon of civil asset recovery and management and seizure and forfeiture in the Commonwealth. I thank you, Madam President.
Senator Hosein.
Thank you. Thank you very much, Madam President, for recognizing me to join this debate on an act to provide for the establishment of the Civil Asset Recovery and Management Agency for the recovery of criminal property through the use of the remedies of restriction in dealings with civil assets, restriction and forfeiture of criminal property, and the management of criminal property and unexplained wealth orders and matters incidental thereto. And Madam President, I am delighted to join this debate because this has been one of the pieces of legislation that has captured the public's interest and the public's attention like no other. Because initially, Madam President, when this legislation was introduced to the public, there were some very worrying provisions that were contained in the former piece of legislation that caused the public stir. However, through a bipartisan approach in the other place, Madam President, the legislation has been now coming to this Honorable Senate in a better form. Suffice it to say, Madam President, that it is not the most perfect piece of legislation that was brought to us, and there's still work to do. And that is why the drafters of our Constitution would have contemplated to have two houses of Parliament so that there will be two different sets of scrutiny so that we can present the best piece of legislation for the taxpayers of this country. Because at the end of the day, this piece of legislation will only benefit the taxpayers once it is drafted in the proper manner. And Madam President, we in Trinidad and Tobago, it's no secret that we are facing one of the most harmful issues, which is that of crime. And when you look at what is fueling our crime, you will see that most of our offenses that take place are because of firearm offenses, because these offenses are gang-related. But Madam President, do you think that the ordinary man on the street could afford to buy these guns, or they can afford to buy these drugs? The money must be coming from somewhere. And Madam President, this piece of legislation may seek to interrogate those persons who will be the one funding the criminal activities on the streets. Because when you look at the FIU report for 2017, you found that there were over $22 billion, $22 billion, which is almost half of the national budget in suspicious activity transactions. So that is worrying. So we are on the one hand grappling crime through the use of legislation. On the other hand, the legislation is also going to attempt to address our international obligation. But Madam President, at the end of the day, we can pass the best piece of law in this Parliament. But what is required is that this piece of legislation is properly operationalized. And I will not go on to repeat the issues by Senator Mark, by Senator Vieira, that this can be used as tools of harassment for political dissidents. But Madam President, we must be cognizant of the situation that we are facing right now. When you look at the civil courts, for example, there's a cause of action founded on malicious prosecution. There are hundreds of cases. There are even judgments where judges complain about the conduct of police officers in this country when they are conducting investigations. And when you look at the various clauses in this bill, you would realize that the moment of investigation, not before a charge is preferred, not before an indictment is preferred, sorry, a charge is laid or indictment preferred, but at the stage of the course of the investigation is when the mechanisms of this bill are triggered. So it goes into giving the police service, the Board of Inland Revenue, and the customs a level of education and training so that when they have this very dangerous piece of legislation, because it's dangerous, Madam President, because you are touching constitutional rights and privileges of citizens. For them to deprive someone of their property, for a court to uphold these orders, there must be a level of proper investigation being done. And when I say that it tramples and touches upon constitutional rights, Madam President, you would see at Section 4A of the Constitution that an individual has the right to life, liberty, security of the person, and most importantly, the enjoyment of property, and not the right, not to be deprived thereof, except by due process of law. So our Constitution contemplates that. And our Constitution also contemplates situations where we are going to touch, and we are going to interfere, and where we're going to limit rights, that a proper procedure must be followed. And that procedure is outlined in Section 54 of the Constitution, whereby if you want to protect and clothe this piece of law from judicial or constitutional scrutiny, what you should do is follow the proper procedure. Insert the preamble in the bill that provides for special majority of this. Because you are, at the end of the day, depriving persons of their constitutional rights. And, Madam President, when you look at the mechanism of this bill, it is three important things. The first thing, it contemplates something called a property restriction order. The second thing you will have is the civil forfeiture procedure. And the third is the unexplained wealth order. So we have the three. Now, when you look at the first one, that deals with the property restriction order. It's a very low standard in which the court has to be satisfied of. The court has to be satisfied that the investigating police officer, during the course of our investigation, has a reasonable suspicion that a specified offense has occurred or was committed. And that is a low level. The same applies to that of the unexplained wealth order and the civil asset forfeiture procedure that flows from a property restriction order. Now, Madam President, one of the most important amendments that was made to this legislation was the definition of specified offenses. And one might ask for the listening public, well, what are those specified offenses? Those are the offenses that are found at the second schedule of the Proceeds of Crime Act, Chapter 1127. And, Madam President, there are 21 of those offenses. They stem from terrorism, they stem from criminal groups, fraud, corruption, bribery, counterfeit, murders, kidnappings, robbery, tax crimes, extortion, forgery, piracy, insider trading, and market manipulation. So there's a host of offenses that are captured, so that you don't go out there, for example, where the former bill contemplated that it dealt with all offenses. Now the police officers and the court must be satisfied that there has been a suspicion of a specified offense being committed. And, Madam President, because of this low level in which an officer needs to satisfy the court of, you would find that more and more applications will be made to the courts, and more orders will be required to be granted. But when you look at what is happening currently in the court system right now is at a go-slow. It is almost at a halt, the criminal justice system on that side. When you look at the civil court system, Madam President, speaking from experience, just last week I was able to get directions in a matter. And I asked the judge whether or not I will have a trial on this side of the year. And, Madam President, you would not believe that the trial date is on...
All right, so Senator Hosein, I would advise you to give your examples without personalizing the fact that you're involved in a matter and talking about it, okay?
I am guided. And, Madam President, I can say, if we're going to use an example, that a trial date for a civil matter, you will get it in February 2020. February 2020. And now we are going to load up the civil courts with more and more of these applications. Because we have the criminal procedure rules where masters are introduced, and they don't have courtrooms for these masters to sit and deliberate on matters. The Attorney General spoke about 100,000 matters are going to be removed from the courts. Well, Madam President, that piece of legislation has not yet been proclaimed. So it is incorrect to say that those matters have been removed. And these are the conditions in which this piece of legislation has to operate under. But, Madam President, when I looked at other jurisdictions, because this is something very novel to us in Trinidad and Tobago, I found that there are three categories of these unexplained wealth orders. The first are those countries that have implemented true unexplained wealth orders and apply them to all offenses and reverse the burden. So we are out of that category. The second category deals with countries that have some form of illicit enrichment provisions that are applicable to all offenses, reversing the burden of proof to defendant in a criminal proceedings. And the third category are those countries with civil asset forfeiture that applies to offenses with a presumption in favor of forfeiture. And, Madam President, we would have fallen in the category where there would have been specified offenses. And the Attorney General did give some examples in terms of Australia having this. Senator Mark went on to indicate, well, listen, Australia doesn't have a Bill of Rights. For example, Antigua and Barbuda, their civil asset forfeiture only relates to money laundering offenses. In Guyana, it's somewhat similar to ours, which relates to terrorism, gangs, drugs, and kidnapping. The UK, it deals with serious crimes. And Bahamas is also similar to us with respect to the proceeds of crime. So we have some models in which we can follow and we can take precedent from in terms of their experiences. But when you look at these jurisdictions, Madam President, there isn't much usage of these orders because it's very difficult in order for these, some of these jurisdictions to investigate these offenses properly. And the Attorney General spoke about proportionality because at the end of the day, when we are trampling on constitutional rights, there must be a level of proportionality that the legislation goes no further than the legitimate aim. Well, what is the legitimate aim? It is that to stifle white-collar crime. However, we have not heard how many matters are before the court, how many of these offenses are being reported to the police, how many of these matters have gone before the court and were dismissed. What is the mischief that we're trying to cure with respect to this piece of legislation? Because when you look at certain provisions, Madam President, and I will get to them in more detail after, you would realize that this piece of legislation, it will cut certain corners that the criminal law can't cut. Because it gives the civil jurisdiction a little more leeway, a little more freedom in terms of capturing the intended aim. And by cutting those corners, we have to really contemplate whether or not those mechanisms would in fact be disproportionate to the legitimate aim, Madam President. And much have been said about that this order, the Attorney General and Senator Simonette, it's similar to a Mariva injunction. Well, I want to give some distinctions with respect to this similarity in which they would have advocated. Now, injunctions, Madam President, as you would know, is an equitable remedy before the court. So you must come with clean hands first to begin with. And before an injunction is granted, you must show that there's a realistic prospect of success. You must give an undertaking as to damages. You must show that there's a risk of dissipation of the assets. And you must all prove these things on a balance of convenience, that it's not unjust, so that one side doesn't favor the other side, Madam President. And especially when you're dealing with equitable remedies, there must be full disclosure. And also the undertaking, as I mentioned. Now, when I look through the legislation, some of these features, which are required in order to get a Mariva injunction from the court, are absent from this piece of legislation. So it may not be entirely accurate to say that this models a Mariva injunction. Now, I want to spend some time, Madam President, with respect to the issue of the retroactive nature of this legislation. Because I want to give an experience that I, through my research, came across in the Commonwealth country of Mauritius. And Madam President, Mauritius had the same problem that we're going through right now. And on the 7th of December 2015, before their parliament went on recess, they decided they had a similar bill like this, to clothe this bill in so much protection that on the 7th of December 2015, they amended their constitution to provide specifically for this bill. And it went on, Madam President, to show that this bill, the bill that they had introduced, infringes their rights, so it's protected. And on the 8th of December, the day after, they introduced their Good Governance and Integrity Reporting Act 2015, which was their almost identical bill to this one. So Mauritius went as far enough as to amend their constitution just for their bill to stand the scrutiny. And that is a responsible process. It shows how important an issue it was to them in order to properly deal with this issue before them. And Madam President, there was a position paper given by the opposition party in Mauritius. And that position paper went through some of the issues with regards to retroactive legislation. And in our bill, that is found at clause 4. And it says that upon coming into force of this act shall apply to all recoverable property, irrespective of whether or not the criminal conduct relative to the recoverable property occurred before or after the coming into force of this act. Now, Madam President, when you look at what they said in Mauritius with regards to retroactive laws, they went back to Magna Carta 1215, and it says that except by lawful judgment of his peers and the land of the law, one should not be subjected to retroactive law because one will conform their behavior to the laws at the time. Now, Madam President, in 2002, in 1995, in 1991, a person had no idea that a parliament was going to include an explain your wealth order. So one would have conformed themselves to that behavior back then, but now they have to be subject to that scrutiny. So for example, if one who was unaware that he would have bought some property or sold some property to somebody who is involved in criminal activities, and there's a live example, it was in our parliament, Madam President, when a former member of parliament sold a vehicle to a well-known drug lord, and it was brought as a motion for scrutiny before the parliament. Now, that person may have died, and this piece of legislation attaches to their estate, or if the person is alive, may not have kept the receipts at the time, may not have kept the agreement at the time. And Senator Vieira made the point that persons now may be more vigilant in terms of keeping receipts because of the advent of technology and the advancement. But Madam President, back then, some people sold cars with the passage of cash, cash in hand. There's no receipt, there's no agreement. And those are issues that we must be cognizant about with respect to our local circumstances and our culture, Madam President, when you introduce such pieces of legislation like this. And the government may argue that, well, this does not apply retroactively, that fraud was an offense, that money laundering was an offense before this act came into place. But Madam President, when you look at the ramifications of this bill, if you fail to disclose or you give an incorrect declaration, a false declaration, it has criminal ramifications. The bill does create offenses. So therefore, you would be facing criminal offenses for matters in which you would have conducted yourself previous to when the act became into force. And now the Attorney General went on to speak about that the orders will attach in rem. So, for example, persons who are listening, when a matter is intituled, you will find the Attorney General against Saddam Hosein or whoever. But now you will find that the matter will be intituled the agency against PAX 1111 or the agency against $100,000. And that will be the intertwining of these matters because it's an in rem order. And Madam President, you would see, I would have listened to the Attorney General, and that is found in Clause 6, that these in rem orders, he said that because it's in rem, it's not a finding of guilt to the person. It's not an in personam order. And I agree with that. I agree with that position. But Madam President, the order itself that is going to be made against a person is an order based on criminal property. And then you look at the definition of criminal property, it must be that which is concerning or has interest with respect to a specified offense. So at the end of the day, the property itself and the person must have been involved because the property cannot commit the crime. The person must have been involved with respect to the commission of a criminal offense. So therefore, if an order is made, an in rem order is made against the property, it still has that connection to the person who has committed the crime. And this is Trinidad and Tobago. If an order is made against myself, or let's just say Senator Mark, that he has to explain his wealth, well, automatically, Madam President, the population will judge based on the law, on the public's perception. And Senator Vieira spoke about compensation. Now, will compensation be enough, or will it be adequate to properly compensate that aggrieved person for what they would have suffered? And those are issues that we must be also very careful about with respect to the low standards that we are setting and some of the provisions that we include in the legislation. Now, there are other provisions which I would like to speak of. What time do we go for lunch, Madam President? Okay. Okay, 1:15. All right, thank you. Because I'm now going to drill into the bill specifically, Madam President, clause by clause. And Section 31, I can go till 1:30, you know. Section 31, Madam President. Let me look at Section 31. Section 31 is, these are the referrals of matters to the Director of Public Prosecutions. So investigation is being conducted. Commissioner of Police, Chairman of the Board of Inland Revenue, Comptroller of Customs and Excise. If they have reasonable grounds to suspect that the offense involves recoverable property, an investigative report must be sent to the DPP. And when this report is sent to the DPP, Madam President, if the DPP is of the view that there is insufficient evidence to pursue criminal charges for a specified offense, but there is sufficient evidence that the property is recoverable, then an application can be made. Now, Madam President, I want to look at the Constitution at Section 90 of the Constitution. And Section 90 of the Constitution clearly outlines the boundaries of the powers of the DPP. And the first boundary is that he must institute and undertake criminal proceedings against any person before any court in respect of any offense against the law of Trinidad and Tobago. So he can institute, then he can take over, and he can discontinue criminal proceedings, any criminal proceedings in this country, the powers of the DPP. But now we are asking the DPP to perform a separate function. You're asking him to perform a function of a civil nature because now he will have to satisfy himself whether or not this matter should go before a civil court. So indirectly, the DPP, the Director of Public Prosecutions, is performing a function in which is of a civil nature, which is not within what is contemplated at Section 90 of the Constitution, Madam President. And we must determine whether or not this is a proper function in which DPP can, in fact, undertake, because if it isn't, then this section of the law will be inconsistent with Section 90 of the Constitution. Now, when you look, again, you go down, it says that the defendant whose property may be the subject of a property restriction order has absconded the jurisdiction, is outside of the jurisdiction, is too ill to face trial, or who has died. Those orders, Madam President, will be permanently ex parte orders. So therefore, these persons have no opportunity to come before the court, because these are the instances in which the court will proceed on an ex parte basis. But I want to drill down a little more in terms of the insufficiency of the evidence for the DPP to move forward, with respect to the DPP to move forward with respect to pursuing a criminal charge. Now, what is considered, what does the DPP consider enough evidence? Enough evidence in order, thank you very much, Madam President.
Honourable Senators, at this juncture, we'll suspend the sitting and we will return at 2 p.m. Senator Hussain, you've utilized 26 minutes of your speaking time.